The Honorable, the President.
Let us pray. Almighty God, we willingly acknowledge you as a supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, I have granted leave of absence to Senator David Small, who is out of the country. Honorable Senators, I have received the following correspondence from His Excellency the President Anthony Thomas Aquinas Carmona, SC-ORTT. The Constitution of the Republic of Trinidad and Tobago by His Excellency Anthony Thomas Aquinas Carmona, ORTT SC, President and Commander-in-Chief of the Armed Forces of the Republic of Trinidad and Tobago. To Dr. Krian Singh, whereas Senator David Small is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Krian Singh, to be temporarily a member of the Senate with effect from the 24th of May 2016 and continuing during the absence from Trinidad and Tobago of the said Senator David Small. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President, St. Anne's, this 23rd day of May, 2016. Honorable Senators, a senator is required to take the oath, so can we please stand?
I, Krian Singh, having been appointed a Member of Parliament, do swear by Bhagavad Gita that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Honorable Senators, I have received the following correspondence from the Deputy Speaker of the House of Representatives. May the 19th, 2016. Dear President of the Senate, change of membership, Joint Select Committee on Social Services and Public Administration. At a sitting held on Friday, April the 1st, 2016, the House of Representatives agreed to the following resolution. Resolved, that Mrs. Glenda Jennings-Smith be appointed to serve on the Joint Select Committee on Social Services and Public Administration in lieu of Ms. Shamfa Kuju. Accordingly, I respectfully request that the Senate be informed of this decision at the earliest convenience. Please. Thank you. Respectfully, Mr. Esmond Ford, MP, Deputy Speaker.
Bills brought from the House of Representatives. As listed on the order paper, the Public Procurement and Disposal of Public Property Amendment Bill 2015 in the name of the Minister of Finance. Papers.
Leader of Government Business.
Madam President, I have the honor to lay on the table the following papers as listed on the order paper and the supplemental order paper in the name of the Minister of Finance, the Attorney General, and in my own name. The audited financial statements of the Police Complaints Authority, the PCA, for the year ended September 30th, 2014. The third report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Northwest Regional Health Authority for the years ended September 30th, 2002 and 2003. The second report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Northwest Regional Health Authority for the year ended September 30th, 2004. The second report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Tobago House of Assembly for the year ended September 30th, 2008. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Land Settlement Agency for the years ended September 30th, 2008 and 2009. The consolidated financial statements of the National Gas Company of Trinidad and Tobago Limited for the year ended December 31st, 2015. The audited financial statements of the National and Entrepreneurship Development Company Limited for the years ended September 30th, 2013 and 2014. The audited financial statements of the National Schools Dietary Services Limited for the years ended September 30th, 2013 and 2014. The annual audited financial statements of the Government Human Resource Service Company Limited for the year ended September 30th, 2015. The annual report of the First Citizens Asset Management Limited for the year 2015. The consolidated financial statements of the Trinidad and Tobago Bureau of Standards for the year ended September 30th, 2013. The fifth annual report of the Police Complaints Authority, the PCA, for the period October 1st, 2014 to September 30th, 2015. The annual administrative report of the Port of Spain City Corporation for the years 2009 to 2010, 2010 to 2011, and 2011 to 2012. And finally, Madam President, the annual audited financial statements of the National Enterprises Limited for the financial year ended March 31st, 2013, 2014, and 2015.
Trade and Industry.
Thank you. Madam President, I have the honor to lay on the table the following papers as listed on the order paper in my name. The annual administrative report of the Trinidad and Tobago Bureau of Standards for the year 2012 to 2013, and the summary of recommendations and conclusions of the 41st meeting of the Council for Trade and Economic Development, COTED.
Urgent questions.
Senator Mark.
Thank you very much, Madam President. Madam President, to the Honorable Minister of National Security. Given the recent media reports about possible terrorist attacks, can the Minister state what steps are being taken to address this issue?
Honorable Minister of National Security.
Thank you very much, Madam President. Madam President, this government is acutely aware of the message posted on the social media concerning the possibility of terrorist attacks on malls and other crowded places, and is definitely not taking anything lightly or for granted. Thus, Madam President, a very robust and proactive measures are currently being utilized by our national security and intelligence apparatus to maintain the level of stability, peace, and good order of our society. This government also recognizes that the global threat of terrorism has not escaped our shores and understands its national obligations in that it possesses the commitment and political will to ensure that the primacy of public safety and security remains its cardinal priority. At this particular time, Madam President, all our law enforcement and security agencies are continuing their dedicated work with a high degree of intensified course of action to protect our citizenry, institutions, shopping centers, and industrial bases from any act of terrorism. We ask all citizens to be vigilant, and if you see it, report it, Madam President.
Senator Mark.
Madam President, through you to the Honorable Minister of National Security, what advice or what steps do you think citizens ought to take in light of these reports that have been circulated far and wide, Honorable Minister of National Security?
Madam President, the advice given to the citizens of Trinidad and Tobago is to be very vigilant, to observe their surroundings, to ensure that they take cognizance of where they are at all times. Security begins with the individual. Additionally, I'd advise them that if they see anything suspicious, to in fact inform the authorities, Madam President.
Senator Sturge.
Madam President, through you, can the minister indicate whether the shooting of the street pastor in Aruca and the shooting which occurred, I believe it was last night in South Trinidad at a church, whether it is ISIS related?
No, Senator Sturge, I will not allow that as a supplemental question.
Which troops then shooting burger?
Two questions have been asked, Senator Mark.
Questions on notice, questions for oral answer.
Madam President, the government is pleased to announce that we will be answering all questions today, including questions for written answer.
Senator Mark.
Question number 47 to the Honorable Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you, Madam President. The National Gas Company of Trinidad and Tobago Limited and their subsidiary companies, the National Energy Corporation of Trinidad and Tobago Limited and Phoenix Park Gas Processors Limited, have been classified as Group A companies. Therefore, the chairman of Group A companies receives a board fee of $10,000 and a traveling allowance of $1,000 per month. The other subsidiaries fall within Group C as per guidelines in the State Enterprises Performance Monitoring Manual. The chairman, Group C companies, receives a board fee of $6,500 and a traveling allowance of $1,000 per month. National Enterprises Limited is classified in Group B. The chairman of Group B companies receives a board fee of $8,000 and a traveling allowance of $1,000 per month. Members, however, receive board fees of $4,000 and a traveling allowance of $500 per month. The fees and allowances payable to Mr. Jerry Brooks amount in the aggregate to board fees of $73,000 per month and traveling allowances of $9,500 per month. The fees and allowances are in keeping with the existing classification of fees and allowances for members of boards of state enterprises, which were approved and established by the previous UNC government. And they are as follows. Company, National Gas Company of Trinidad and Tobago Limited, board fee $10,000, traveling allowance $1,000. National Energy Corporation of Trinidad and Tobago Limited, board fee $10,000, traveling allowance $1,000. Phoenix Park Gas Processors Limited, board fee $10,000, traveling allowance $1,000. Libre Industrial Development Company Limited, board fee $6,500, traveling allowance $1,000. NGC CNG Company Limited, board fee $6,500, traveling allowance $1,000. NGC NGL Company Limited, board fee 6,500, traveling allowance 1,000. Trinidad and Tobago NGL Limited, board fee 6,500, traveling allowance 1,000. NGC Petrochemicals Limited, board fee 6,500, traveling allowance 1,000. NGC Pipeline Company Limited, board fee 6,500, traveling allowance 1,000. National Enterprises Limited, board fee 4,000, traveling allowance 500. Thank you, Madam President.
Senator Mark.
Madam Chair, Madam President, I beg your pardon. Could the Honourable Minister indicate whether the policy of having one individual, in this instance, Mr. Jerry Brooks, chair all these subsidiaries of NGC, is this a policy that the government intends to review or revisit, or is it now standard policy for one person to chair all these subsidiaries?
Thank you. The Honorable Senator may recall that on a previous occasion when I came to this esteemed House, I would have responded on the issue of Mr. Jerry Brooks having been appointed as the chairman of all these subsidiary companies. And if you do not recall clearly, we did indicate that given the state of this group of companies at the time, we determined that it was in the best interest of bringing the company back into some semblance of proper management and governance, that we would have had the chairman of the parent company sit on, as the chairman of the subsidiary companies. And this is in the interest of really reining in that company and ensuring that there's proper governance structures throughout the company. Thank you.
Senator Mark.
Madam Chair, Madam President, I beg your pardon again. Could the Honourable Minister indicate whether the chairman of the NGC, who is also chairman of all these subsidiaries, is entitled to a chauffeur, and is that chauffeur paid for by the state?
Minister of Energy.
Well, I view that as a different question, but I will oblige and respond. In accordance with the State Enterprises Monitoring Manual, I mean, the governance of boards and the allowances to board chairmen are identified in that document, and the chairman of boards are not allowed to a chauffeur. Thank you.
Senator Mark. No. Question number 54.
Oh, I thought you asked me for supplement.
No.
Yeah. Yes, thank you very much, Madam President. Question number 54 to the Honourable Minister of Agriculture, Land and Fisheries.
Minister of Agriculture.
Thank you, Madam President. I thank Senator Mark for this important question. Madam President, the Office of the Commissioner of State Lands has surveyed the Claxton Bay area along the Cedar Hill Road east and west, heading in the direction of the Southern Main Road, and has reported that there is some squatting on small parcels and plots in the area, as well as on surrounding former Carney 1975 limited lands, now vested in the state. The Commissioner of State Lands is in the process of taking necessary follow-up action to deal with this matter. But patrols and conduct of encroachment surveys are in progress, and quit and eviction notices will in due course be served on persons found to be in illegal occupation of state lands. The occupiers will be given 14 days to vacate, and failure to do so will cause the Commissioner of State Lands to proceed to the Magistrate Court to initiate the judicial process for removal of any such squatters. Honourable Senators should also note that the Ministry of Agriculture, Land and Fisheries has advertised for additional enforcement officers to assist the Commissioner of State Lands in executing his functions with respect to matters of this nature. I thank you.
Through you, Madam President. Mr. Minister, could you indicate to the Honourable House approximately how many squatters have been identified in those said areas that you spoke about?
Minister of Agriculture.
Madam President, I'm not in a position to advise on the specific numbers. All I could say is that Based on LSA, Land Settlement Agency records, across the country, there are more than 65,000 squatters on state lands. So it's an issue that the ministry is aware of. It's an issue that we're dealing with.
Senator Hadeed.
Question. Has the minister been able to assist the various squatters in the different areas as to when regularization to those who were there prior to the cutoff date will be done, and in what time frame do you have in which to give the ease to the squatters?
Senator Hadeed, I will not allow that. That's not a supplemental question that I will allow.
Okay.
Senator Mark.
Yes, could the Honourable Minister indicate whether he's aware that persons who are in occupation of lands along the Claxton Bay, Cedar Hill area are being illegally evicted by squatters or persons who claim to be owners of properties in the context of this question of land grabbing? Is the Minister aware?
Minister of Agriculture.
Madam President, back to my original answer. The Commissioner of State Lands is dealing with the issue of squatting, and if it involves fighting among squatters and fighting among people who claim to be the owners of the land, the Commissioner of State Lands under the law is a person who is responsible for that, and he's dealing with it.
Senator Mark.
Thank you, Madam President. Question number 55 to the Honourable Minister of Agriculture, Land and Fisheries.
Minister of Agriculture, Land and Fisheries.
Madam President, this newly constituted Ministry of Agriculture, Land and Fisheries, under the new PNM government, inherited a substantial outstanding debt owed by the previous UNC government to National Flour Mills, dating as far back as January 2015. I'm pleased to say that thus far, the ministry has settled its indebtedness to NFM on behalf of the farmers, inherited from the previous regime, in the sum of $6,178,212.63. Thank you.
Senator Mark.
Question number 56 to the Minister of Finance.
Minister of Trade and Industry.
Thank you. Madam President, the government, since the implementation of the new VAT regime on February 1st, 2016, has ensured that consumers are provided with relevant, accurate information on the new VAT rate, as well as a detailed list of all zero-rated goods and VAT-exempt services. This information was disseminated to the public by the Ministries of Finance and Trade and Industry through their websites, press releases, and print advertisements. Additionally, a hotline was set up by the Consumer Affairs Division of the Ministry of Trade and Industry, and a dedicated team of communication officers were identified at the Ministry of Finance to handle all calls and queries related to the new VAT regime. This communication drive has enabled consumers to make more informed decisions and has reinforced the application of the new VAT regime for the business sector. The government has also put in place the necessary systems at the Inland Revenue Division to ensure that the reduced rate of VAT at 12.5% is charged by all VAT-registered individuals and businesses, and the said rate is now being applied to recently standard-rated goods and services. Madam President, the government has addressed all breaches of the new VAT regime that were reported to the Consumer Affairs Division by citizens over the period February 4th to March 8th, 2016. The process included notification to the businesses accused of breaches and reinforcement that the new VAT regime must be properly implemented by all VAT-registered businesses. The Consumer Affairs Division has followed up with the relevant businesses and has confirmed that the identified breaches have been corrected. The breaches included not properly identifying zero-rated and VAT-able items on invoices, as well as not reducing the rate of VAT to 12.5%. Madam President, The Consumer Affairs Division of the Ministry of Trade and Industry will also continue to protect the economic interests of consumers by embarking on projects and programs that will focus heavily on price determination and price monitoring. This has already been initiated with the recent publication of the Supermarket Prices of Items booklet, which highlighted the results of a price survey on 146 grocery items across 42 supermarkets throughout Trinidad.
President, could I ask the Honourable Minister of Trade and Industry whether, since this question was posed and given what she has just indicated, are there any further breaches that has come to the attention of the ministry, and what measures or action is being taken by the ministry to protect the consumer rights in this country?
Minister of Trade and Industry.
Thank you. I'm pleased to inform you that there have been no further breaches reported by the Consumer Affairs Division on their usual mission to supermarkets. There have been no further breaches.
Madam President, may I also ask the Honourable Minister, how often do the officers of the Ministry of Consumer Affairs visit these supermarkets and conduct surveys to determine, whether the supermarkets and those other businesses are keeping in line with the regime that the Consumer Affairs Division has outlined for them to be guided by?
Thank you. The Consumer Affairs Division is out there in the field, and they continue on a monthly basis to visit at least 40 supermarkets throughout Trinidad and Tobago. And you would notice that these are now published on the ministry's website, as it's quite costly. I think I said in this house to do so in the newspapers. I think it's costing us about $60,000 to report in 4 newspapers. So we've been doing it monthly, and we will continue to monitor both for breaches and for, of course, in general compliance with the VAT regime. And of course, educating the customers by the publications on the websites and in social media.
Madam President, if I may again, as the Honourable Minister, citizens of this country, Madam President, who do not have access to the internet, how do we seek to educate them and to raise their awareness, given what you have just said? Because they don't have access, but the information is there. It is not in the newspapers, and from what you are saying, it's very expensive. How do customers or consumers get that level of consciousness and awareness of their rights?
Yeah. Every quarter, they will be placed in the newspapers on a quarterly basis.
Senator Amin.
Madam President, to the Minister, previously it was reported in the newspaper that the advertisements indicated the supermarkets to be visited before they were visited. That in fact serves as a warning, so supermarkets could get their act together before the officers visit. Since that initial report, have you changed the method in terms of not sending that warning by advertisement before, and so that the supermarkets will be, in fact, visited by surprise, perhaps?
Yeah. Sorry. It is on only one occasion, and this is on the introduction of the system of visits to supermarket, that an indication was given to the public that we will begin visits to supermarkets, and that they would have started in Point Fortin. So it was on that only occasion that notice was given. Other than that, they have been going around to supermarkets without notice, except the courtesy of the day in question that we are going to be here. That's it.
Dr. Singh.
Thank you, Madam President. Honorable Senator and Minister, my question is it considered a breach where they raise the price of the item while still lowering the VAT so that they themselves have made more profit? Is that included in your list of breaches?
Member, the ministry does not engage in price setting by suppliers.
I'm aware of that, but I'm asking, is it considered a breach? Was it one of the reported breaches where consumers are paying more for a product even though the VAT has been reduced at the market?
Remember, the ministry does not engage in price setting by suppliers.
So therefore, it's not a breach?
It's not a breach.
Okay.
Government business.
Madam President, thank you for granting me leave in accordance with Standing Order 32 to raise a matter directly concerning the privileges of this House. The matter concerns certain public statements allegedly made by former temporary Senator Mr. Gerald on or around Thursday, 11th of May 2016, which were damaging reflections on a temporary member of the Senate in the performance of his duty. Reflected on the exercise by temporary Senator John Kerr of his rights to vote in this Senate during the passage of the SAS Bill 2016, Mr. Ramdeen allegedly to have made the following public statements, among others. 1. Quote, Independent Senator Justin John Kerr, who voted with the government on the SSA Amendment Bill in the Senate on Tuesday, was employed by the Attorney General's office since 2015. 2. They understand what was taking place. They understood that the truly independent senators were not going to support the SSA bill. And if it is that this is what it must come to for the government to pass legislation, then we as an opposition and the independent senators consider is in a breach of the fundamental rights of the citizens of Trinidad and Tobago. Then we are in serious trouble in Trinidad and Tobago. We are in deep trouble, unquote. 3, quote, at no point in time did Mr. Justin Jonker indicate to the Parliament that he was on the payroll of the Attorney General while this bill was going through the House, while it was such an important part to be played by the independent senators, and seven of the 9 independent senators voted against this bill. It is a matter of public record now how Mr. Justin Jonker voted. 4, quote, the information was very disturbing and meant that Jonker should not have been allowed to serve on the independent bench, unquote. 5, quote, the opposition would also seek to determine whether there was a breach of the Integrity in Public Life Act or whether there is any remedy that resides in the powers of the President, be they constitutional or any other, that he may have one. Madam President, these statements were widely reported in several daily newspapers. Additionally, the newspaper reported, quote from former temporary Senator Ramdeen, as indicated, that he intends to write a letter of objection to His Excellency President Anthony Carmona over the appointment of independent Senator Justin Jonker. Madam President, parliamentary privilege is not a new concept. In fact, it is the hallmark of parliamentary practice and our democracy. Historically, it was a right designated to protect the right of the king to the service of his advisors. By the 16th century, Parliament itself was assuming the jurisdiction to regulate privilege, and thus privilege was increasingly being used to protect the fledgling Parliament from the powers of the Crown. I wish to underscore the word protect, Madam President. Parliamentary privilege therefore remains the bedrock of the working of a Parliament. It offers protection from the interference from whatever source. It safeguards the freedom, authority, and dignity of this august House. Section 55(1) of the Constitution of the Republic of Trinidad and Tobago states, and I quote, subject to the provisions of this Constitution and to the rules and standing orders regulating the procedures of the Senate and the House of Representatives, there shall be freedom of speech in the Senate and the House of Representatives. Madam President, the alleged action of former Senator Ramdeen cannot be ignored. If the statements attributed to him are true, Madam President, we cannot turn a blind eye. To ignore such conduct will signal to all my colleagues on the independent bench and to every one senator here that we do not possess those sacred rights of freedom of speech and freedom to vote. Madam President, it is for these reasons that Mr. Ramdeen's alleged reflection upon then-Senator Jonke's participation in the proceedings of the Senate, as reported in the press, amongst to actions intended to molest, impeach, and intimidate the former temporary senator. Madam President, it is well established in the laws of Parliament that where action go beyond the realm of seeking to influence and become intimidation, then Parliament must uphold its right to prosecute for contempt. Numerous cases have been found in the UK, Canada, and New Zealand. In our jurisdiction, in 2009, the House of Representatives sanctioned Udicot for the publication of a statement in the form of a full-page advertisement in response to a statement made by an MP, concluding that it was a contempt of the House by seeking to intimidate the member in the execution of his duties as a member of the House. Madam President, the Senate must likewise shield its dignity and reprimand any person who engage in conduct of this nature. As a consequence, Madam President, of the foregoing, I submit that if these purported statements and reflections are true, Mr. Ramdeen has committed a most egregious act of contempt of the Senate by egregious, by making statements which were intended to intimidate and may have intimidated Senator Jonke in the conduct of his work as a senator. 2, reflecting on the character and conduct of Senator Jonke in such a manner that brought this Senate into ridicule and odium. 3, seeking via the Media and Integrity Commission to impeach former temporary Senator Jonke in relation to his participation in proceedings in the Senate. And 4, making entreaties to His Excellency the President Anthony Thomas Aquinas Carmona, ORTT SC, to censure Senator Jonke for his choice to vote as he did in the Parliament. It is for these reasons, Madam President, that I move that this matter be referred to the Committee of Privileges of the Senate.
Honourable Senators, I received a copy of this privilege motion via the Office of the Clerk of the Senate this morning. All that I am required to do at this stage is to rule prima facie that a case of breach of privilege exists. The decision on whether the matter referred to is indeed a breach of the privileges of this Senate falls to the Committee of Privileges. Honourable Senators, I have carefully considered this matter, and having regard to the facts presented via the motion, as well as established parliamentary practice and procedure, I am satisfied that prima facie a case of breach of privilege has indeed been made. Accordingly, I refer this matter to the Committee of Privileges for its consideration and report.
Request for leave to move the adjournment of the House on definite matters of urgent public importance.
Senator Mark.
Thank you very much, Madam President. Madam President, in accordance with Standing Order 16 of the Senate Standing Orders, I wish to discuss a definite matter, or raise rather, a definite matter of urgent public importance. And that is the failure of the government to effectively address or deal with the intolerable and unprecedented rising tide of murder and homicide in the country. The matter is definite because our citizens continue to be slaughtered like animals on a daily basis, which has brought the murder count for the year to a horrific and unprecedented 196 persons as at today's date, and with no end in sight to arrest this ugly scourge which has blotted our once peaceful landscape. The matter is urgent because despite dedicating 3 ministers with different portfolio responsibilities to the Ministry of National Security, the government is still unable to produce any effective plan to deal with the escalating crime wave and thereby prevent our citizens from being murdered virtually every day in this country. The matter is of public importance, Madam President, because the outrageous and out-of-control murder rate has plunged the population into a perpetual state of fear and insecurity, which constitutes not only an attack on their constitutional right to life, liberty, security of the person, and the enjoyment of property, but poses a direct embarrassment to our country as it seeks to attract investors and visitors to our shores. Thank you very much, Madam President.
Honourable Senators, I'm not satisfied that this matter as presented qualifies under this standing order.
Public business, private members' business, motions.
Honourable Senators, you may recall on the last occasion when this motion was being debated, I made the decision not to preside over said motion. So therefore, we will suspend this sitting for 10 minutes so that the Vice President can assume the chair. So this sitting is suspended for 10 minutes.
Follow the Parliament of Trinidad and Tobago on Twitter. Our call sign is @TTParliament. You're viewing the Parliament Channel 11, also broadcasting on 105.5 FM.
to 4 Knox Street has been the site of a municipal building since 1899, when this key area around Woodford Square was home to several significant political and religious buildings. The present City Hall is a distinguished example of 1950s architecture, which reflected a move away from traditional colonial styles towards a more modern and functional aesthetic. In 1899, Cocoa Baron and Deputy Mayor Leon Agostini sold the property to the City Council for the sum of $38,000, and from then on it has been used for municipal purposes. Between 1899 and 1907, the Town Hall housed barristers' chambers, club rooms, and governmental department offices. A devastating fire in 1948, however, destroyed the building, and as a result, the administration of Port of Spain was conducted from the Prince's Building, which was at the south of the Savannah. Architects Pryor, Lorenco, and Northnagel were hired to design the new town hall. The architecture of the building came out of the post-World War II modernist movement. Trinidad and Tobago was developing quickly, and independence was in the air. There was a lot of interest in creating architecture that was moving in a new direction, away from traditional modes of building. The architecture of City Hall was adapted for the climate in a style that was called tropical modernism.
If you look at a number of features of the building in terms of common areas and the way that certain areas were naturally ventilated, the way that certain areas don't rely on air conditioning. And also if you look at the plan of City Hall, on the north side of Woodford Square there is a kind of courtyard area that opens out onto the sidewalk. They're buildings that were designed in consideration of the climate. Features were designed in terms of the building envelope, the circulation spaces, and there was a sort of maximization of the natural ventilation potential of the building. And also its relation to the sun at different times of the day, I think were carefully considered in buildings.
Large windows and well-placed breeze blocks allowed the open offices to be filled with light and air. Unlike previous colonial municipal buildings, the new City Hall was an accessible public building that also fit into the surrounding environment without dominating it. Even the auditorium used for various cultural and municipal purposes was designed to be easily accessed by the public from the street. The new building was a move away from architecture that was assertive and authoritarian towards something more encompassing.
But I think it was attempting to be a public building and to fit into the landscape. If you look at the scale of it along Frederick Street and along Woodford, from the elevation on Woodford Square, it's not a dominant building. Its scale is consistent with the buildings around it. And again, if you look at the way that the little courtyard space and the way that the hall opens out onto the sidewalk, these were all gestures that I think were intended to break down that notion or idea that a government building was something separate and represented an authority, but it was part of a much more democratic process and a softening of the line between the private sort of world of the administrative domain, the government society, and the public dimension of society.
In 1958, the foundation stone for the new City Hall was laid by Princess Margaret. Just 3 years later, in 1961, the new building was completed and renamed City Hall. It became the seat of the municipal government for Port of Spain. A mural by acclaimed artist Carlisle Chang, entitled Conquerabia, can be found on the ground floor of the building. The name of the piece comes from Port of Spain's original Amerindian name. The 41-foot mural is like a plan of Port of Spain. The Red House, the Old Town Hall, and several key buildings are etched into the concrete. Amerindian motifs are included, as well as images that represent the diverse religions of Port of Spain.
The Carlisle Chan piece in there I think is a very interesting feature of the building. And if you look at a lot of buildings from that time, they did integrate works of art. A number of buildings in Port of Spain did that. And I think that this building, works very well in the way that that piece is integrated, and I think we should do a lot more of that.
Port of Spain City Hall is emblematic of a time when colonial institutions were being dismantled in favor of a more open and local approach to governance. Worthy of preservation, the building is a landmark in our modern governmental history.
Parliament Outreach.
The roles and responsibilities of an MP is to ensure that he carries out about his duties and that he makes sure that his constituency is being taken for.
The lecture series today was very informative, especially from Mr. Hamed Ghani. He made me very aware of what is mostly the main role of an MP, what happens, what ministers are supposed to do, and what processes the Parliament goes through in deciding a bill.
I think the role of an MP is to seek the interests of the people in the area, deal with the matters that are pending and like give everybody a fair chance to state their problems and things that they think the MP should do to uplift the area.
Parliament Outreach. Check our website for showtimes, ttparliament.org. You're viewing the Parliament Channel 11, also broadcasting on 105.5 FM.
Who is starting? Yep. Honourable Minister, Leader of Government Business.
Thank you very much, Mr. Vice President, for the opportunity to join in this debate. You're supposed to read out? Yeah, here. Mm-hmm.
Right. Honourable members, the debate on the following motion, which was in progress when the Senate adjourned on Tuesday, March 22nd, 2016, will be resumed. Whereas the Central Bank of Trinidad and Tobago is established under Chapter 79(2) of the laws of Trinidad and Tobago as a body corporate with the purpose to promote monetary credit and exchange conditions that are most favorable to the development of the economy, and whereas as the institution that manages monetary credit, exchange conditions and interest rates, central banks worldwide are expected to be independent of political interference, and whereas the bank is managed by a board of directors and the day-to-day management of the bank is entrusted to the governor, who shall be appointed by the president for a period of 5 years, and whereas Section 10(1) of the Central Bank Act stipulates that the governor shall be answerable to the board for his acts or decisions, and whereas there has been no public disclosure by the board of directors or otherwise with regard to the apparent reasons for the dismissal of the governor owing to his actions or decisions, be it resolved that the Senate condemn the actions of the government in its dismissal of the governor of the Central Bank on December 24, 2015. List of those who spoke: Senator Wade Mark, mover of the motion; the Honourable Colm Inbert, MP; Senator Dr. Danashar Mahabir, and Senator Wayne Monroe. Honourable Leader of Government Business.
Thank you very much, Mr. Vice President. Mr. Vice President, again, it's an honor to join this debate on this private motion moved by Senator Wade Mark, which reads as follows, and you have just read it out in detail, so I wouldn't bother to go in. But it closes off by saying, be it resolved that the Senate condemn the actions of the government in the dismissal of the governor of the Central Bank on December 24, 2015. Mr. Vice President, the Central Bank is the most important financial institution in this country. Because of that, the position of governor of the Central Bank is a pivotal position in the financial system. It is a position of great influence and requires great trust. It calls for competence, for experience, and a measured approach to the job. And I want to go on record in this Parliament, Mr. Vice President, to say that this government would not have acted flippantly nor irresponsibility, and it considers this extremely irresponsibly in such a serious matter. We will not. But Madam President, when Senator Danishra Mahabir spoke, he took some time to outline the rules of the central bank. And obviously he's more eminently qualified than I am to so do. But let me just recap what some of the main functions of a central bank are. First and foremost, as mentioned by Senator Mahabir, is an issuer of notes. It is it has the sole monopoly on notes issue in almost every country. It acts as the banker, the agent, and advisor to the government. It is responsible for the stability in inflation rates, in exchange rates, and in interest rates. It is also the banker's bank, meaning that it is the custodian of all cash reserves of the commercial bank. It is a lender of last resort. And very importantly also, it is a clearing agent. And Mr. Vice President, central banking has a long history. Just for the records, I mean, this was some of my research. Central bank, Sweden created the world's first central bank. I think it was alluded, possibly that was the Bank of England, but the records show that Sweden created the world's first central bank, the RIKS, R-I-K-S, in 1668. The Bank of England came next in 1694. Napoleon created the Banque de France in 1800. Congress established the Federal Reserves in 1913. The Bank of Canada began in 1935. The German Bundesbank was re-established after World War II. And very importantly also in 1998, the European Central Bank replaced all central banks under the Eurozone. So basically, central banking is something that is global, and it has very, very serious connotations to the financial stability of any country. The Central Bank of Trinidad and Tobago was established by Act 23 of 1964. And Mr. Vice President, throughout, from 1964 to present, as a country we can boast of having some of the most profound thinkers acting as governor of the Central Bank. We started with Victor Bruce, immortalized Tobagonian, is now in the financial complex in Tobago, the Victor Bruce Financial Building. We went on to somebody of the caliber of Dr. Uric Bob, a national scholar coming from Presentation College, San Fernando. Good? We had Winston Dukaran, politician turned central banker, returned to politics, and now I guess is a university lecturer and is charting something called the Caribbean. It's a book I got recently from the university. So Victor Bruce, Uric Bob, Winston Dukaran, and Hubert Williams. 4 stalwarts in the financial system of Trinidad and Tobago. Yeah. Willie Dimas. And he would hear word and couple of, but just summarizing the key guys. And now, Mr. Vice President, we have to understand that this is not an emotional issue, because banking is not emotional. The central bank and what it does and what it cannot do and what it has to do is governed by legislation. It's not governed by what we like or what we don't like, what we prefer or what we don't prefer. It is governed by legislation. The Central Bank Act, the Exchange Control Act, and the Financial Institution Act. Those are the 3 pieces of legislation that has the greatest bearing on the operation of the central bank. The Central Bank Act and this legislation determine how the governor is appointed, how the governor can be terminated, and it defines in clear terms the relationship between the governor and the Minister of Finance. It's not what we want the relationship to be or what we perceive it to be. The relationship is clearly defined in law. For the records, I will read into the records, Mr. Vice President, how the governor is appointed. Section 7 of the Central Bank Act states as follows. The governor, deputy governors, and other directors shall be appointed by the president by instrument in writing. The governor shall be appointed for a term of 5 years, the deputy governor, so on and so on. Shall be appointed by the president. Minister Imbut, when he was here the last time around, explained when you say president without any further qualification, it means the cabinet. So the cabinet appoints the governor. How can the governor be terminated? The president here, meaning the cabinet, may terminate the appointment of the governor, that's section 12 of the Central Bank Act, or deputy governor, or any director, if the governor, deputy governor, or director, A, becomes of unsound mind or incapable of carrying out his duties. B, becomes bankrupt or compounds with or suspends payment to his creditors. C, is convicted and sentenced to a term of imprisonment. D, is convicted of any offense involving dishonesty. E, is guilty of misconduct in relation to his duties. F, is absent except on leave granted by the board from all meetings of the board held during 2 consecutive months or during any 3 months in any period of 12 months. FA, fails to comply with section 16(1). FB, contravenes any provisions of any prescribed code of ethics in respect of which he is liable to termination of his appointment. FC, becomes disqualified for holding office by virtue of section 9. And G, fails to carry out any of the duties of function conferred or imposed on him under this act. And let's now deal with the relationship with the Minister of Finance. And this idea that the central bank governor is an independent republic is not so in law. He obviously has to interface because these are the 2 key financial players in the economy. One who is part of the executive, one who runs the central bank and has some quasi-autonomy and independence, but not total independence because it is controlled by the executive through the Minister of Finance because the cabinet appoints, the cabinet can terminate based on the grounds that I have just said. And the law now clearly defines the relationship between the central bank governor and the Minister of Finance. Part 4, relations with the government. The bank shall act as banker to the government and shall be entrusted with such government banking business in Trinidad and Tobago and abroad as may be assigned to it by the minister. Check how many times the minister comes. That may be assigned to it by the minister. So it cannot conduct banking business unless it's been assigned by the minister. 46. The bank may make temporary advances to the government on such terms and conditions as may be agreed upon between the bank and the minister. It continues. 48. The bank shall, on terms and conditions as may be agreed between the minister and the bank, act as an agent for the government in the payment of principal and interest and generally in respect to the management of the public debt. Most importantly, 49. The bank shall keep the minister informed of the monetary and banking policy pursued or intended to be pursued by the bank. This is fundamental to the legislation. The bank shall keep the minister informed of the monetary and banking policy pursued or intended to be pursued by the bank. They have to have regular meetings and the Minister of Finance must be briefed on monetary and banking policy. 50. The minister may, after consultation with the governor, issue to the bank such written directives of a general nature as may be necessary to give effect to the monetary and fiscal policies of the government. The central bank doesn't get up one morning and make fiscal and monetary policy for the country. An executive is elected into office to do just that. I repeat, 50. The minister after consultation with the governor, issue to the bank such written directives of a general nature as may be necessary to give effect to the monetary and fiscal policies of the government. The central bank does not make policy. It is the government through the cabinet that makes policy for Trinidad and Tobago. That is why we face the people. That is why you are elected into office, because you offer them a manifesto. You offer them policy as to how you want to take this country forward. So this fiction that was articulated by Senator Mark, that the central bank governor is independent to do whatever he wants. It is not so. It is false, because it is governed by legislation. So you cannot have a bravado central bank governor. And let us go chronologically now with what transpired. As I said, this matter may go to court, so I do not want to jeopardize anybody's position as it relates to that. On the 4th of December 2015, the FITI address by the governor of the central bank on the 5th Monetary Policy Forum. And the central bank governor went on for the first time to indicate to this country, whether right, wrong, or indifferent, and I quote from his speech, 4 consecutive quarters of decline in real GDP in 2015 means Trinidad and Tobago is now officially in a recession. Nothing is fundamentally wrong with that statement, you know. But to announce to the nation that your economy is in recession, and without having the courtesy, nor following the law, to indicate to the Honorable Minister of Finance that this is what you are going to say, especially since the statistical information to back that was always in question, because there's no CSO in Trinidad. Okay, so you could have probably coined it in a more guarded phrase, because when a central bank governor, when the director of the reserves in America, the Federal Reserve speak, when Greenspan spoke, I mean, the world trembled. So here you are making such a fundamental statement. The bank shall keep the minister informed of the monetary and banking policy pursued or intended to be pursued by the bank. So obviously, ladies and gentlemen, this was bravado. I say no more. And then comes another issue that was raised by the Minister of Finance during that period. The central bank, at its September 2015 meeting, the central bank's monetary policy committee agreed to increase the repo rate for the 7th consecutive time by 25 basic points to 4.5%. It went on in December to increase the repo rate by 25 basic points to 7.75%. All these are monetary policy. You have to inform the Minister of Finance. So, the governor of the central bank, for whatever reason known to himself only, never did that. And then came the other major transgression, which was the announcement of the users of foreign exchange. And it goes like this, the central bank statement. Let me just get it here. And then here the tenor of the language. Here the tenor of the language, Mr. Vice President. In the month since Central Bank, and I quote from the speech here, Mr. Vice President. In the month since the Central Bank made its $500 million intervention, I have been asked about 500 million times. You hear the rhetoric. Rhetoric doesn't come from a banker. You know. A banker has striped suits, well tucked away tie, Wall Street guys, and they measured in what they say. In the month since, hear him, in the month since the Central Bank made its $500 million intervention, I have been asked about 500 million times, where has all the money gone? That is not the word of a banker. Here is the answer. And he went on to indicate the retail and distribution sector is the most voracious consumer foreign exchange. And then he went on to list all the people who were, all the companies who were, not in the interest of transparency. Now, here is where it comes curiouser and curiouser. On this statement was made on December 4th. On December 10th, on the Central Bank website, the Central Bank statement is and quote, the disclosure of information on the local business community's use of foreign exchange was lawful, necessary, and in the best interest of Trinidad and Tobago financial system. That was our Central Bank post on December 10th, 6 days after the statement was made. If you go to the Central Bank website now and you try to download this address, it is downloaded without any reference to names. And there's a caption here on the front page which says, information related to individuals and companies have been removed from the original text dated December 30th, 2015. Obviously, the Central Bank has rethought its position. And this text has not been posted in its entirety. Because within their own board of directors, they must have come to the conclusion that this was a breach of the law. Then came the complaint from the Trinidad and Tobago Chamber of Industry and Commerce, the Neil and Massey Group, Mr. Jove Warner here. We had our legal team work over the weekend, etc., etc. He could share your personal information or my personal information. I think it's a really dangerous precedent, and anyone in Trinidad should be concerned about it. You had letters written to the Minister of Finance from Smith Robinson, from Massey Group, from you name it. They all complained, indicated that they interpreted to mean a breach of the law. And let's see what the law states. Section 56 of the Central Bank Act states, except insofar as may be necessary for the due performance of its objective, and subject to Section 8 of the Financial Institution Act, every director, officer, and employee of the bank shall preserve and aid in the preserving secrecy with regards to all matters relating to the affairs of the bank, any financial institution or person registered under the Insurance Act, or of any customer thereof that may come to his knowledge in the course of his duty. It is clear, Mr. Vice President. It is extremely clear that that section of the law was broken. If you go now to the Financial Institutions Act, Section 8. Confidentiality. Financial Institution Act. No director, officer, or employee of the central bank. Here how specific. No director, officer, or employee of the central bank or person acting under the direction of the central bank shall disclose any information regarding the business or affairs of a licensee or any of its affiliates or information regarding a depositor, customer, or any other person dealing with a licensee that is obtained in the course of his official duty. How much clearer you want it than this, Mr. Vice President? How much clearer you want it like this? Section 44 of the Exchange Control Act states, no person who obtains information by virtue of this act shall disclose that information otherwise than in the discharge of his function under this act or for the purpose of any criminal proceeding. But nothing in this subsection shall apply to information lawfully received by a member of the public in the course of an ordinary transaction between such a person and the bank. So you had a breach of the Central Bank Act, the Exchange Control Act, and the Financial Institution Act.
The debate finished?
The debate is finished. It really is. And I just want to... Section 56 of the Central Bank Act was breached. Section 8 of the Financial Institution Act was breached. Section 44 of the Exchange Control Act was breached. And let me make a fundamental statement here. And I refer to Senator Daneshwar Mahavir's comments. I think he had a very, very good debate. We were enlightened by the depth of his analysis. But he did conclude that he supported the disclosure because it was in the public interest. And that is his right. I make no further comment on that. But having said that, Senator Mahavir will know that in academia, the biggest non-violent crime in academia is plagiarism. In banking, the biggest offense you can commit is breach of confidentiality. Look, Mr. Senator Shrikissoon is shaking his head. The biggest transgression you could have in the banking system is a breach of confidentiality. That will collapse the banking system. That is why you have Securities and Exchange. That is why you have Security and Exchange Commission for insider trading, because information is privileged at that level. It can collapse a banking system. And when you play flippant with confidential information in the way that this thing has happened, there's absolutely no cause except to take the action that we took. And it's all well and good to say in the public interest. And there is something called the public interest. But the legislation is crystal clear. To quote Mr. Manning, it is pellucidly clear.
That's right.
Okay? As to how we need to operate in situations like these. So it is my thesis, and it is the view of this administration, that the Minister of Finance had to act, the Cabinet had to act, and we are a responsible organization, we are a responsible government, and we must act to keep the stability of the financial system intact. Because there's nothing, confidence is what has destroyed the exchange rate, or is just attempting to destroy it. Because the bank continues to tell you we have reserves for 11 months. But yes, there's a drain on the foreign exchange. And the reason for that is because the banking system is based on confidence. Confidence on since Wells Fargo had a stagecoach dropping money all over the United States of America. The Wells Fargo Bank is still one of the largest banks in America. Okay? And this is at the crux of the financial system. And we cannot play flippant in dealing with matters like that. Anything else, you might get away with it. But not in banking.
Exactly.
Not in banking.
Sound financial management in banking.
And finally, as I said, I wouldn't be speaking too long on this thing because I was just making these basic points because it is it may become a sub-judice matter because the former central bank governor has written a pre-action protocol letter, and we will see how that goes on. But let me just conclude, Mr. Vice President, on you talking about the central bank and political interference. And let me show you what is political interference and what is subterfuge by the United National Congress. When the UNC came into power in 2010, I think September 2010, no, May 2010, in November of 2010, in May 2010, the governors of the central bank were as follows. Let me just I will get the information for you now. The governors of the central bank of May 2010 were as follows. Ewart S. Williams, chairman of the board and governor. Ms. Joan John, executive director. Dr. Sheldon Nichols, executive director. Ms. Alison Lewis, former permanent secretary in the Ministry of Finance, non-executive. Ms. Barbara Chatu, non-executive. Ms. Amelia Carrington, senior counsel, non-executive. Mr. Norris Campbell, non-executive. Mr. Carlisle Graves, non-executive. And Professor Selwyn Kojo. There were 6 non-executive members and 3 executive members, 9 members on the board of the central bank. It is reported that in November 2010, Mr. Dukaran reportedly directed non-executive directors to resign. Remember that? Whether you want to accept it or not. But they resisted and sought the opinion of senior counsel who advised against his instructions. An attempt was made to have the president replace directors Dr. Selwyn Kojo, Carlisle Graves, Amelia Carrington, and Barbara Chatu, whose term expired in 2012, but this failed. The minister, in an attempt to tip the balance, then forwarded the names of Robert Myers, Dr. Roger Hussain, Larry Lala, Rabindranath Moonan, you know that name? Rabindranath Moonan. Carl, on to HDC. He was proposed for the central bank initially too, you know. Good. Shida Bolai to the president. Myers and Bolai publicly declined for their names to be advanced. And the minister succeeded in getting Hussain and Lala to replace retiring director Alison Lewis, his own permanent secretary, and accountant Norris Campbell. Sources reported that the Ministry of Finance prepared a list of 10 new members to the board. This would have brought the bank's board to 19, tipping the balance overwhelmingly in favor of the minister's chosen team. However, they settled finally on seven new members. Steve Sitahal, Inshan Ramsarup, Bahindra Sunil Maharaj, Beverly Khan, Wayne Tikai, Neil Mohammed, and Joseph George. And here the statement. Persons virtually unknown in the financial community.
What do you expect from that?
Senator Mabe, you know any of these fellas' name? Or ladies? They didn't even offer the distinguished economist a position on the central bank board. Okay. But at least give you the opportunity to decline.
Why did you not do the same thing?
Okay? And that is the level of foolishness that went on. With the UNC government. Okay? And you know why, Mr. Vice President? I'll tell you why. To tell you what is called subterfuge. And I make no apologies for that statement, subterfuge. You have a board of a central bank. You cannot replace them like how you replace ordinary boards. So you have to let them serve out their term. The president wouldn't revoke their appointment. You'll just accept that. Okay? But here what Section 5 of the Central Bank Act says. The bank shall be managed by a board of directors, comprised of a governor, not more than 2 deputy governors, and not less than 6 other directors, 2 of whom may be public service directors. But there's a lacuna in the law, because most articles of association and even statutes for statutory authorities, that organizations that are formed by statute, they give you a minimum and they give you a maximum. But there's no maximum here. It just says that it must have a minimum of no less than 6 directors. So they went ahead now and appointed 7 new directors to outvote the existing directors. So you ended up with a situation. The largest central bank board in the world. Okay? The board I'll give you the information here now. On September 30th, 2011, the board of the central bank consisted of 17 people. 17, because of subterfuge, because they use a lacuna in the law. That is different when you're dealing with legislation. When you're using legislation for governance, this is just a lacuna in the law. And here what it says, 17 members of the board of the central bank. By comparison, the United States, with a population of 300 million, maintains its system through the Federal Reserve Board, comprising of 5 members. Little Trinidad and Tobago have 17. The European Central Bank, formed in 1980-something, I think I just said, responsible for 17 countries with a population spread of 500 million people. And the whole Eurozone, the European Central Bank manages its currency through 6 members.
Oh my God, 17.
So 5 of the Federal Reserve, 6 in the European Central Bank. The Bank of England, operating since 1694, has 12 directors. The highest, the Bank of Canada, with responsibility for 100 banks and 700 credit unions, has 14 members, but nothing close to 17. 14, 12, 6, and 5.
We were complex. We needed help.
So, Mr. Vice President, I just brought this to the attention of your good self, through you, to the Honorable Senate and to the national community. This is what you call political interference in the bank. That is political interference. Where is the independence that you know purporting? Because a particular governor who clearly would have breached certain regulations and in fact, and was being bravado with his statement, certain actions were taken against him, and you come here now to file a motion asking the Senate to condemn the government's action. This is what the government should be condemning. This is what the people of Trinidad condemned you. That is why you lost the election in
Honorable Leader of Government Business, you have 5 more minutes.
Okay, yeah. I don't plan to use it. Okay? So I will wrap up. Mr. Vice President, I have clearly indicated that the government didn't act flippantly nor irresponsibly in the cabinet informing the president to terminate the appointment of the former governor of the central bank. I have clearly indicated what laws were breached and how, in our opinion, he put the whole financial system at risk, because confidentiality is at the core of the financial system in any democratic country in the world. And just as a matter of comparison, I brought to the attention of the Senate, through you, Mr. Vice President, certain actions that were taken by the then Minister of Finance and the United National Congress Cabinet, where they tried subterfuge in appointing one of the largest boards in the history of Trinidad and Tobago in terms of the central bank in particular. And when I compare it with the statistics of the Federal Reserve, the Bank of England, and the Bank of Canada, and the European Bank, it was really an abuse of process, to say the least. So, Mr. Vice President, it is obvious that this side of the House will not be supporting this motion, and I encourage most of the senators on the independent bench in particular to do likewise. I thank you very much.
Senator Hadeed.
Thank you very much, Deputy President. I stand in support of the motion of my colleague and to refute quite a bit of what the last speaker, the Honourable Minister, proposed to the Honourable House. First of all, who is Jawala Rambaran? He's well qualified. He was well qualified for the position that he was kicked out and fired for. He was very well qualified. The previous board, the previous governors of the central bank, first of all, it was John Pierce in 1964 to 1966, Dr. Alexander MacLeod, 1966 to 1969, Victor Bruce, 1969 to 1984, Uric Bob, 1984 to 1988, William DeMass, 1988 to 1992, Thomas Ainsworth Harewood, 1992 to 1997, Winston Dukaran, 1997 to 2002, Ewart Williams, 2002 to 2012. Every single one of these honorable gentlemen served out their full term of office. Not one of them was fired or had cause to be fired. None of them. Why? Why? I would say the only one that was fired was Jawala Rambaran. Why? I'll give you the reason why. As early as April of 2014 in this honorable House, the then opposition leader, opposition member of parliament, Colin Imbert, signaled that Jawala Rambaran was not suitable for the job and he was an on-the-job trainee. This was long before the now government came into office. Rambaran reminds me of a game that is called skeet shooting. I don't know if you know what that is about. You have a clay pigeon and you have a line of people waiting with shotguns. And you fly the skeet and everybody shoot at the clay pigeon. Well, Rambaran was a clay pigeon. Why? Because all of the members, a lot of the members of the business community lined up against him. Why? Because he had the good sense to advise the country of the questions the people were asking. Who was the users of the foreign exchange? I do not buy, Minister, of what you talked about of the members of the government, the members of the community who are customers of the bank. They are customers of the commercial banks. They are not customers of the central bank. So if a complaint had to be made, it was the commercial banks to make the complaint that the governor of the central bank did something wrong. Nobody in Trinidad and Tobago, except possibly the Minister of Finance, was surprised by the statement that the country was in a recession. Nobody but him. But everybody knew what the governor of the central bank was saying was the honest truth. He got punished for speaking the truth. In an article on Sunday, November, in The Guardian, 2014, the question is where is the US dollars going? Where is it going? And the TTMA asked questions, and I will quote some of it. Speculation is a real problem as the global currency exchange is largely unregulated. On the issue, Investopedia says despite the 20% increase in daily foreign volumes between 2007 and 2010, commercial transactions by corporations and governments actually declined by 10% over this period. And they went on to say, one can see how the activity can be how it can destabilize economies if not properly regulated, as this kind of trade has the potential to cause wild fluctuations in the value of currencies. What I'm getting at is when you have a Minister of Finance interfering in the daily workings of the central bank, you're going to find yourself in a situation where people will lose confidence in the institutions. What everybody also knows is that the policies being put in place to deal with the situation are not working and are unworkable. The then Governor Rambaran had to answer questions on a daily basis of the shortage of foreign currencies for the business community to do transactions. Everybody was asking him, where is the money? He keeps putting in the money, where is the money? The central bank puts in regularly at intervals what the oil companies don't sell to the commercial banks. So what does he do? He's caught in a position of trying to defend his position of where the money is going. With no confidence in the economy, you will get hoarding of your foreign exchange. Nobody will sell foreign exchange to the bank because they're worried that when they want to get foreign exchange, they can't get foreign exchange. This puts our currency under strain, and there's no question that the pressure will get worse. Without credible policies, we would lose control of our currency, and it will sink beyond any hope of salvage. I pray that this Minister of Finance stops interference. Stop interfering with the workings of the central bank. Now, more than ever, we need international support, and that requires confidence in our financial institutions. Recently, the head of BP said, we have to stop bashing foreign investors. It seems to me that every day something appears in the papers condemning foreign investors coming to Trinidad to invest their money. We must stop this. Yet this is the very time that the Minister of Finance has chosen to act outside of his delegated powers, outside of his remit, outside of the mandate to get the governor of the central bank fired. Not for cause, not for logic, not for reason other than political victimization. He was like a clay pigeon waiting to be shot down. That is what they had prepared for him. He had no chance whatever of survival. We all know that the dismissal of the governor of the central bank was not more than political victimization. In fact, in June of 2014, then opposition MP Colm Imbert, contributing to a motion on the government's failure to deal effectively and with the ongoing foreign exchange crisis, described Rambaran as an on-the-job trainee. Imagine, an engineer who built a wall that ended up in the Diego Martin River and a building in Grenada, a stadium in Grenada collapsing, calling a professional on-the-job trainee. The then opposition member, Imbert, accused Rambaran of having no experience managing a large operation. I'm speaking the truth. He said, I'm speaking the truth, and I'm going to take full responsibility for that. The governor of the central bank has introduced a system where 90% of the available foreign exchange is auctioned to 212 foreign exchange dealers, including foreign exchange dealers who have a very small customer base, giving large sums of foreign exchange to financial institutions that don't need it. The source is Renuka Singh, Trinidad Guardian. I'm quoting from the Trinidad Guardian. This kind of sniping in the dark creates a corrosive environment, a poisonous environment, which affects not only our central bank, but all of our financial institutions. Mr. Deputy Speaker, Mr. Deputy Vice President.
Mr. Vice President.
Oh, Mr. Vice President. Sorry. I am aghast as a businessman to know that when you take away the credibility of an institution, it takes decades to rebuild it. One must always work with the establishment and try to ensure whatever you do in your position of authority, it is not done with vengeance or malice. It must be done in a way to build confidence. It must be done in a way to bring one another together. Our problem here in Trinidad and Tobago, for all to see, is a division. The division that we have for one another, even here in this chamber. Why? We are here to do the work of the people who have asked us to come and work for them, because they all can't fit in this chamber. Each one of us represent a segment of the society that when we speak to one another, we must work in the benefit of all. This is what we need to do. And by singling out and creating an environment where it is either me or you, wouldn't work. Don't care how many governments and how many governments go. Many will come after them. But we must all remember, don't single out institutions to destroy the institutions. They are part of the constitution of this country. The independence of the central bank was severely and seriously compromised. And the situation has gotten much worse. People cannot get foreign exchange today to pay their bills. They're rationing foreign exchange at $100 or $200 when you go to the bank. What causes this imbalance? What causes the imbalance? I'll tell you. Too few business people need too much at the expense of the balance of the people in Trinidad and Tobago. Too few. And this is all that Rambaran was pointing out. A handful of commercial merchants, a handful of commercial merchants who bring no foreign exchange back into the country but send it out to make a profit. How many of them that he has named to date can say, I have sold this and I have gotten foreign exchange to return to this country to ensure that we have a replenishment of what they're spending? How many? I would say almost none of them. Because when you look at them, it's either food, motor car, medicine, whatever. But they're bringing nothing back in. And they are consuming a third of all the foreign exchange that passed through this country in the last 5 years. That's the amount of money. The business community, you want me to call the names? You want me to call the names? I am speaking the truth.
Senator, please address the chair.
Sorry, man. Sorry, sir. I'm being distracted and I like to answer the distractions. The Minister of Finance seems, at this present time, to be the de facto governor of the central bank.
Yeah.
It appears to all. I want to challenge the Minister to publish, the Minister of Finance that is, to publish the opinion he received from the various different sources he stated in his December 24th, 2015. And he stated the cabinet decision was based primarily on legal advice from both internal and external counsel, including senior counsel, who advised that the disclosure by the former governor of the names of the largest users of foreign exchange in Trinidad and Tobago and the amounts of foreign exchange that used was a breach of Section 56 of the Central Bank Act and Section 8 of the Financial Institutions Act. In addition to this, Cabinet took note of the fact that there was a need to restore confidence in the confidentiality of the banking system and in the governance of the central banks. The banking system, not the central bank. The banking system is different to the central bank. You lose confidence in the banking system when you have a Minister of Finance interfering and calling out FCB on issues relating to one of his own ministers. That is when you lose confidence, sir, in the banking system. He preached one thing and practiced another thing. The only people who have lost confidence in the head of the central bank was the Minister of Finance. He's the only person. Every person who replaced the governor, even the person who replaced the governor, said he supported the position taken because it was a bank decision and not just the governor. It was a bank decision. I will quote something here. It's good to know. This was reported in it was published on Sunday, November 24th, and the source of The Guardian, Natalie Briggs. And they went on to say, Farrell had also questioned the move to allow non-financial institutions to so much access to U.S. currency when they did not have the strong know your customer and anti-money laundering processes of the larger banks. According to the former deputy governor, another question of which a foreign exchange is going arises. The central bank provided, this is in 2014, August 2014. The central bank provided some answers in their economic bulletin of August 2014. This is long before Jawala Rambaran made a statement. This is 2014, what I'm going to quote here. Of the injections so far, purchases were made by the following. 30.9% of US $1,038 billion was used by the retail and distribution sector. 22.4% or US $752.9 million by credit card centers. 14.1% or $474 million by manufacturing, and 8.1% or $275 million went to the automotive dealers. Over-the-counter purchases by individual members of the general public amounted to purchases worth 2%, a mere 2% or $67 million. Despite the amounts, there are still problems. An informal check by Sunday Business Guardian with customers in lines at banks last week revealed that some customers were still not able to purchase as much US dollars as they would like. In its release on Friday, 20th, 2014, the central bank said that they would conduct a special sale of US $50 million and that these funds were being released to facilitate trade-related demands, especially for small and medium enterprises. That was August 2014. Nobody said anything then. Why? No election was in the air. Nobody didn't want to have an issue with anybody. This was published by the central bank. We heard nothing from the business community, the sharpshooters. We heard nothing from the trade unions. We heard nothing from the then opposition, who is now the government. Heard nothing. But all of a sudden, election in the air, April, statements was made about Rambaran being an on-the-job trainee by the then opposition member. And lo and behold, elections are won, and up goes the clay pigeon, and the shots are fired. Who claims the clay pigeon? The Minister of Finance. I claim the shot. I shot the sheriff. Let us try to understand how by publishing the names, I went on to say, now that the Minister of Finance is so confident about the advice he got to fire the governor, then publish it. Let us also get access to the legal advice and see if it was objective. Let us see if that is really what was said. He's known, this Minister of Finance is known to stretch his imagination, you know. Let us try and understand by how publishing the names of the organization which use up our country's scarce resources in any way undermines the operations of the central bank. Our position is that what was done was consistent with the bank's mandate and its commitment to public interest. Not the government's interest, but the interest of all the people of Trinidad and Tobago. Today, people line up, wait and beg for a few dollars. And nobody says a word. You all fully believe that the big shots are reloading and hoarding the foreign exchange, so they get nothing. We here demand that we get the information so that the public could know the truth about the opinions that that Minister of Finance received. The Act states that the bank should only preserve secrecy where doing otherwise would hurt the operations of the bank's policy. It is very clear that the bank's policy has not been hindered by the governor's shedding of light and clarity on the matter. Everyone except the minister's friends can see that this is a hollow ruse. The clear message to the outside world at the time of doubt and uncertainty in government's policy is that if the leaders of our principal institutions tell it as it is, they will face the sack. They will face the sack from this Minister of Finance. People are afraid to speak. When you stifle speech, you impede the democracy of your country. People then go into hiding and plan and plot behind your back. Let democracy prevail. Open the information that you have received, that you keep cloistered for yourself and your friends. Let the country know what these so-called opinion lawyers have given you, so that we would not have to stand up here and condemn the information he has that nobody else has. I am saying, do not stifle information that can be made freely so that the people can understand. The people's money is who you are guarding. It doesn't belong to any of us in this house. It belongs to the people. And they must know how the money is being spent. It is their duty to know it. And I stand here with my colleague and support the motion and hope that we get full support from that side, this side, and the independent bench. Thank you very much.
Senator Shrikissoon.
Thank you, Mr. Vice President, for allowing me the opportunity to join into this debate. And I'd like to say, as I begin this evening, and having listened to the contribution of the Honourable Senator Khan and Senator Hadeed, there are two key words that are being presented here, and from Senator Khan's presentation, that of confidence, and Senator Hadeed's presentation, that of institutions. And I think both senators would have really hit at the heart of the matter as it pertains to Trinidad and Tobago, the development of Trinidad and Tobago, the confidence in the systems we have, and the confidence more so in the institutions that pertains to the development of Trinidad and Tobago. As everyone in this honourable house would know, that I have been making a clarion call to all stakeholders for the development of institutions in Trinidad and Tobago. Because as I've showed before, in several reports, and more so the Global Competitiveness Report, the institutions in Trinidad is really lagging behind in terms of supporting our competitiveness and growth. So in this light, I would like to contribute to this debate in terms of the development and confidence of the institutions in Trinidad and Tobago. Here before this honourable house today is a situation involving the government and the governor of the central bank. My contribution here today serves to ventilate what I would call or refer to as the facts of the matter as available to me, an individual. And therefore, I want to pay some special attention to the timelines over which this event or these events occurred. Just want to remind everyone that it was on Friday, 13 July 2012, that the then governor, Jawala Rambaran, was installed as governor. And in May 2014, it was that governor who introduced a new system of distribution of foreign exchange. And it was around that time of introducing that new system that the public began to make a public outcry indicating that the adequate levels of foreign exchange were not accessible at the commercial banks. And therefore, a lot of it was ascribed to the changing of the system at that point in time. The reality of the situation is that in 2014, just about $6–7 billion was requested by the public for trade, of which the banking system could have only collected $5.5 billion, therefore leaving the central bank with the only option to intervene with a whopping $1.7 billion in foreign exchange in that year, 2014. What occurred in 2015 was quite similar, with the demand for foreign exchange being $7.3 billion, with the highest ever in the country, and the purchases by the commercial banks just being about $4.9 billion, leaving a gap of $2.6 billion US. Where would this $2.6 billion come from? And it was central bank who was again intervening. So the problem here was really a demand and supply situation where the demand for foreign currency outstripped the supply, and therefore it required central bank's intervention. The problem here was not, as I said before, was not in the functioning of the system that the governor introduced, but a mere fact of supply and demand. And I believe because of the public outcry, it was because of this reason that the Honorable Minister of Finance in his budget presentation 2015 to 2016 acknowledged the public outcry and acknowledged the shortage of US currency, and therefore in his presentation said that he would have instructed the central bank to revert back to the old system while putting in $500 million additionally into the system. He was making this request. And so the intention of this request was to clear the backlog of arrears that businesses in Trinidad and Tobago were signaling that they had to meet, obligations they had to meet, which they could not. And therefore, what occurred subsequent to the minister's statement in the budget was a directive given to the central bank to revert to the old system as well as release. The central bank and the governor, in adhering to this request of the new government, released or gave a press or media release, and it says here on October 29, 2015, media release via the Central Bank of Trinidad and Tobago, it says here, acting on special directives, the central bank has re-established the foreign exchange distribution system, and point 2, consulted with the commercial banks to ascertain the amount of foreign exchange required, and the central bank will make a special injection of $500 million US. The wording of the press release has some element of concern to me, because it's saying here, acting on the special directives of the central bank. Acting on special directives, this coming from the new government and the minister. Now, we understand that in law, or according to the Central Bank Act, that the minister can give a special directive. But the central bank was not unaccustomed to making injections. So then why on this occasion a special directive had to be given? And I'm very concerned about that, because if it is that you have an officer, the governor, managing the monetary affairs of the country, making injections in the past, and then all of a sudden we have a new government, and in order for them to intervene, a special directive had to be given. It is of concern. And so the special injection that was required, or that was mandated, I should say, was done just at the end of October. And on November 15th, a mere 2 weeks after the injection, and I wish to quote Mr. Vice President, Guardian article November 15th, 2015, visits by the Sunday Guardian to several banks throughout Trinidad and Tobago last week revealed that customers and small businesses were only being afforded up to $200 US per day. Upset customers who called the bank about their woes were merely directed back to the commercial bank. One bank executive, speaking under the condition of anonymity for fear of victimization, explained that trade creditors were responsible for the quick absorption of the US $500 million. She said the concern for currency now stemmed from the fact that the quick absorption meant little ease to the daily hassle faced by the bank's clientele. The money is gone, she says. So here it is, after the injection, you have still the same public outcry. As Senator Hadeed said, TTMA, Trinidad and Tobago Manufacturers Association President, former Senator Ralph Balgobin, agreed that the money was already utilized to pay off existing debts incurred by the business community. They required more funding. DOMA, head of Downtown Owners and Merchants Association, DOMA, Gregory Aboud, said he too understood that the business absorption took the majority of the latest injection, leaving private citizens in difficulty. My point here is after the special mandate, which was supposed to relieve the concerns of the business community and citizens, did not materialize. So then I beg the question, why then was the special mandate? Was there someone saying that this may not really address the issue? And so, because his hands were tied, really, probably so, they decided that we needed to do this, and it could only be done through a special mandate. However, that was up to November 15th. We're 2 weeks after the injection. And I want to quote again from an article, Tuesday, November 17th, from the Newsday. Government is seeking to find out where the recently released sum of US $500 million has gone. The money was released by the central bank just a few weeks ago to address shortages in the supply of foreign exchange for the upcoming Christmas season. Prime Minister Dr. Keith Rowley made the disclosure to reporters at the office of the Prime Minister in St. Clair. Mr. Vice President, herein lies my issue. The government comes into office and issues a mandate to the governor of the central bank. The governor of the central bank executes the mandate. And when the desired result is not achieved, the Prime Minister engages the use of the $500 million through a public medium. You have a situation where a government moves in, discusses a situation with the governor, the public is made aware after. But when the public cries out, before going back to the men on offices that would have carried out the mandate, we sought to ventilate the issue in public. And herein lies the issue, or herein lies two key institutions, the Ministry of Finance and the Central Bank. You've collaborated before and come up with a plan. The issue was that the directive was given through a mandate, but when it did not work, we engaged one of the institutions through a public medium. That I have a concern with. If a working relationship was at least executed before, then why wasn't it maintained? And if we are to treat financial security of a country as national security, this treatment of information would not have entered the public domain as it did. And so I'm saying, in the context of building institutions, there must be systems to be followed to address any shortcomings, rather than ventilate so freely through the public medium. You could have simply engaged the institution and asked for a report, and you would have known what would have been the result of the mandate you would have executed. Simple. Rather than going out into the public. So it comes out into the public. The public is making a statement that they're still having difficulty. The Prime Minister adds to it in such a way that he issues a concern and he wants a report why, after a member of his government issued a mandate. And so the public again is in the same position a mere 3 weeks after the mandate was given. What was the basis of the mandate, and why ventilate publicly like that? But then we have a response. And the response coming from the governor at this point in time. And so my issue here with this again is that we've been told of the qualifications of the director and the process of the governor and the process that has to go through. And if it is that one institution or one organization or one arm of state may have erred by ventilating an issue publicly, was there a requirement to respond publicly? Was there a requirement by the governor to respond publicly? And so what was happening is that the governor now is under more pressure, having conformed to the special directive of a policy that fails to bring about any long-term solution, and the issue is now ventilated all over the place. And so the governor, at his 5th Monetary Policy Forum on Friday, December 4th, sought to address what he thought in his mind was the best way to deal with this issue. And at that presentation, he released several names of companies that would have utilized foreign exchange and said it publicly. There was an outcry as to whether or not the confidentiality was breached. And questioning the governor's judgment, in questioning the governor's judgment, the governor sought to issue a press release on December 8, 2015, central bank statement on allegations of breach of confidentiality. I'm not going to read the entire thing. And the governor says here, the central bank, and I just want to highlight a point here. When the governor was making his contribution at the 5th Policy Forum, he introduced himself as governor, as I, and having how many months in office again. But when it comes under scrutiny, all of a sudden, we move away from ourselves and we hide behind the institution. If we are to adopt a principle here, if it is the institution we are representing, abide by the institution. Don't go out in the public, make statements on an individual level, and then use an institutional defense for it. And so he says here, the central bank hastens to record and remind of the relevant and applicable statutory provisions which empower it in the due performance of its objects. And he says here, Central Bank Act, and the governor here is seeking to justify what his position was. And it says, except insofar as Senator Khan was saying, as may be necessary for the due performance of its objects. Subject to Section 8 of the Financial Institutions Act, every director, officer, and employee of the bank shall preserve and aid in preserving secrecy. The opening line, except insofar as may be necessary. This is according to the Central Bank Act. Who determines what is necessary? And in simple terms, if I am to define what necessary is, because I am not in any way legally sound, or in terms of having that experience, necessary in my reasoning says, what would have occurred if this information was not released? Was it necessary? What would have occurred if this information was not released? And in my mind, the public would have still had the outcry if the information in terms of who were the recipients of foreign exchange was not released. And therefore, in my mind, it was not necessary because nothing would have happened and there was no consequence for non-release of the information. That was his first point. His second point of defense says, and he used the Financial Institutions Act 7909, and he says here, where the central bank determines that the disclosure of further information concerning a licensee, in addition to that referred to in subsection 5, and subsection 5 really refers to the provision of financial statements of an institution. So it says here, and if I'm just to reread it in that context, it says, where the central bank determines that the disclosure of further information concerning a licensee, in addition to that referred with respect to an analysis of a financial condition, of a financial situation of an institution. So what is really happening here is that he's using a line of defense saying that in the best interest of Trinidad and Tobago, this information should have been revealed. But the aspect of the act that was being used, the section 8.6, really refers to the central bank using its regulatory power over its institutions and not governing its operational activities. This aspect of the Act pertained to the central bank deeming a financial institution presenting a risk to the financial system. And it is only under that context, if the financial institution was presenting a risk to the financial system, that disclosure should occur. So in my mind, the two aspects of the law that the governor used for his defense, in my mind and in my humble view, I don't think was 100% accurate in terms of his defense. And as Senator Khan pointed out later on in the same legislation, under Section 8, which refers to confidentiality, and Senator Khan read it, no director, officer, or employee of the central bank or person acting on the direction of the central bank shall disclose. No officer. And if we go on to subsection 7 of that same piece of legislation, it says, nothing in this section authorizes the central bank or any person acting under the direction of the central bank to disclose information about a particular depositor or creditor of a licensee, except where such disclosure is required by any written law or ordered by the court. So the question is, could the defense that the central bank used for the actions of the governor stand? And in my mind, I really don't think so. So you have a situation where where an institution or the government engages the governor publicly and ventilates an issue publicly when there could have been good collaborative effort. And then you have a situation where the governor is responding to it publicly and then using a line of defense, which I really don't think justifies his position. So therein lies the issue in my mind. And how do you respond to that? This motion brought before us here also speaks of political interference. And whether the central banks worldwide, as I quote from the motion, are expected to be whether central banks worldwide are expected to be independent of political interference. In an article posted on the 29th of the 10th, 2013, on the Bundesbank of Germany's website, it's entitled "The Road to Central Bank Independence." It says, the Central Bank Council of the Bank Deutscher Länder fought vigorously for full independence so that it could protect the new currency. This was just after World War II. The Central Bank Council, with complete seriousness and gravity, finds that the independence of the central bank is an absolutely decisive element of securing the currency's stability and maintaining confidence in the currency, according to the minutes of the Council's meeting, 4th and 5th April 1950. The central bank and the government finally reached an agreement that the central bank would commit to support the general economic policy of the federal government in the fulfillment of its task. This passage was inserted into the Act. Members of the federal government were permitted to attend central bank council meetings and submit motions, yet had no voting rights. And this practice was followed throughout Europe at that time. So here it is that we're seeing a central bank operating in full independence, not having any political influence. But if we compare closer home what has occurred and we go to the Eastern Caribbean Central Bank, it says here that the bank was established on October 1st, 1983. But the main decision-making body of the Eastern Caribbean Central Bank is the Monetary Council, which is made up of the ministers of finance of each member territory. So here it is, on one extreme, you have complete political independence, and on the other extreme, closer to home, you have political influence, where the ministers of government or ministers of finance comprise the board of this institution. So what really exists in Trinidad? And in the Trinidad context, we must recognize that the economy is very dynamic. Section 49 of the Central Bank Act, according to Senator Khan, as he read, the board shall keep the minister informed. Section 50, the minister may, after consultation with the governor, issue to the bank such written directives, as we've seen after the new government assumed office. Therefore, we're seeing that the Central Bank Act prescribes some element of a working relationship between the Minister of Finance and the Central Bank. In his speech on March 4th, 1967, at the formal opening of the bank's new premises, the Minister of Finance, A.N.R. Robinson, may his soul rest in peace, had to say this: in this matter of relations between the central bank and the government, the policy of the government has been to leave the bank completely free in its day-to-day operations, and there can be no question of any interference with the bank in the discharge of its technical functions. The Central Bank Act gives the bank wide statutory powers, but contains checks and balances on the actions of both bank and government. It recognizes the ultimate responsibility of the government for the peace, order, and good government of the country, and specifically for the coordination of monetary and fiscal policies. In this way, it is assured that the bank will have the maximum degree of independence consistent with the responsibility to the community as a whole. Here it is, we have a situation, an architect of the Central Bank Act specifically stating that there must be a working relationship, and a working relationship should be established. But I want to say this. At the close of the 5th annual forum held by the governor, was where the governor spoke, he says, in his closing remarks, the governor at that time says, the appropriate monetary and fiscal policies can only come, and I think this is very important, the appropriate monetary and fiscal policies can only come from the central bank and the Ministry of Finance working together. The sitting governor at that time said that. He says we have no choice. We can and should work together to ensure that we get the policies right. But in his closing remarks, just 2 lines below that, he says, we will all be double damned if spite, vindictiveness, and ego keep us from working together to help our country. And so you're seeing two offices recognizing the need to work together, but personality clashes are interfering with the governance of key institutions. And I'll say this a little bit later on in the presentation, but again I'm saying as an independent senator, the goal here is not who wins. The goal is to develop institutions that will carry our nation, our people, and our business community forward. It is not about right or wrong, but it is about what is in the best interest of the country. And that should be the overriding policy at any given time. And even if one is wrong, is there a way that it can be worked out so as to preserve the integrity of the institutions which really we depend on, which has been taking a bashing internationally for not presenting Trinidad and Tobago in a competitive light? And the actions here bringing the Ministry of Finance and the Central Bank into disrepute internationally cannot contribute to the positive nature of the institutions of our land. And so the only people responsible for this can be the leaders of our land. And I'm not saying government alone. All leaders of our country, all leaders of institutions must recognize the role and function that we have, and that personality clashes is not a reason that we should engage in order to resolve a problem. Institutions, and that's the key factor here. How would we have dealt with this situation with respect to the governor of the central bank and the Minister of Finance having a level of difficulty? And I am saying the way forward for us has been prescribed by our predecessors. And I want to quote from Mr. John Pace, one of the first governors of the Central Bank of Trinidad and Tobago, as governor for the period 1964 to 1966. John Pace's departure from the bank amid some acrimony was due more to clashes of personality and his apparent dissatisfaction with the pace at which things were moving. But the central bank was not about to engage in open conflict with the government. Having emerged from the womb of the Ministry of Finance, it necessarily had to have a close working relationship with the ministry. Governor 1 of Central Bank Trinidad and Tobago. Dr. Alexander MacLeod, in his farewell speech as governor in July 1969 of the Central Bank of Trinidad and Tobago, he says here, a central bank has a difficult task to perform. On the one hand, it must endeavor to cooperate with the fiscal and economic policies of the government, for clearly it cannot manage the economy by itself. He says, and this is his closing line, it is a matter of reasonable men on both sides taking a reasonable view of the public interest. But I would be less than frank if I did not admit that things do not always go smoothly. And today I'm asking the question, did reasonable men act reasonably in the interest of the public? And I want to say my own view is I think that this situation could have been handled differently. And so in keeping with the thrust of institutions, and I'm saying that since for many years institutions have been compromised in this country, and the people of Trinidad and Tobago are the people who are affected most by the failure of these institutions, we as leaders of this country, we all have the right to ensure that institutions under our care represent the interest of the public fairly and in the best interest of the people at all times. And I'm saying this in this context, if you'll allow me, Mr. Vice President, to make an observation here which I would like many to think about with respect to this institution, the institution of the Parliament and the institution of and our Senate, as well as our independent bench. 2 weeks ago, we engaged in a debate on the SSA Amendment Bill. Senator Small was absent and Senator Justin Junke was appointed as senator. Senator Small returned to the country and served as chairman of the Joint Select Committee on State Enterprises on May 9th. But the second session of the Senate debate on the SSA bill was on the 10th of May. So then if Senator Small was in the country on the 9th, then in what capacity was Mr. Justin Junke invited to this special meeting with the AG on the 9th?
Honourable Senator, I do want to remind you that Madam President, in her capacity as President of the Senate, did mention that this particular issue will be sent to the Privileges Committee. So I just want to guide you as you make your contribution in thing.
Thank you, Senator. Thank you, Mr. Vice President. But all I'm saying in this situation is that we are supposed to be building institutions. And I'm not dealing with the issue, or I'm refraining from dealing with that issue. I'm saying the institution of Parliament, the institution of the independent bench. In what capacity? Because clearly the oath of office was taken on the 10th, the instrument of office was supplied on the 10th, but we had a meeting on the 9th. Yes. And in my view, that affects the workings of the independent bench. Yes. And so with respect to this bill that is before us, I am saying that institutions in this country is under threat, and more specifically. So I am saying, Senator Taurel Shrikissoon is saying, I'm seeing the institution being threatened, not the institutions not working in the best interest of the public, Ministry of Finance and the Central Bank. I'm seeing here that an event that occurs that affects the independent bench, which I personally am not too happy with. And then I'm saying If we are to move our country forward, institutions should be built and not be interfered with by personalities. So, Mr. Vice President, on this note, the wording of the motion says to condemn the actions of the government. But I cannot do that because there are other areas that I disagree with as well. The way in which the governor himself responded publicly. And I'm saying here, so I have difficulty in supporting the motion and how it was worded, but I would have preferred that the situation be handled differently. And so I'm saying, as I close here, that as individuals and as leaders of our land, let's pay attention to the institutions that we govern and that we lead, because our people are depending on us. Thank you, Mr. Vice President.
Honourable Minister of Trade.
Thank you very much, Mr. Vice President, and I'm very pleased for this opportunity to enter this debate. Although I would want to say upfront that I'm going to be guarded in my comments, insofar as this is a matter that may very well end up before the courts, and I would be concerned about responding to some of the statements that have been made here this afternoon. And let me just say something about Senator Shrikissoon's comments. I very much like your presentation with regard to independence, and it's something that I will like to speak to in the course of my debate as well. But I wish to put on the record, however, that there has been no personality clash whatsoever between the Minister of Finance and the former central bank governor. And let me say without doubt that it is under this administration, this government, that in fact all of the institutions in this country will be rebuilt. My colleague, Senator Khan, did address the question of the purpose of this central bank insofar as reinforcing the importance of this great institution. And I myself did quite a bit of research and looked at the mission statement of the central bank, went onto the website, and for the sake of public information, again, say that the mission statement of the central bank is the promotion of such monetary, credit, and exchange policies as would foster monetary and financial stability and public confidence and be favorable to the economy of Trinidad and Tobago. And I think thus far in all of the discussions this afternoon and on the last occasion, we have stopped short about the whole business of public confidence, and I will come back to that. So that the goals of the central bank, I think, have been recited clearly by my colleague, Senator Franklin Khan, in that they are required to provide the country's currency with price stability. He also spoke of the regulatory authority of the country's monetary policy, the whole question of being a provider of notes and coins and being a government banker and the banker's bank and the lender of last resort as well, insofar as offering loans and to banks and other eligible institutions, and also in terms of managing the country's foreign exchange. And of course, we know that it best functions in its capacities when it is independent, yes, from government fiscal policy and uninfluenced, but it stops there, Mr. Vice President, and I will go into the role, the dual role of the governor of the central bank and the Minister of Finance. And I want to say that, yes, the central bank is all that I said and my colleague had said, and these are all, in fact, the matters which a central bank governor is required to preside over. And these are, in fact, we will all agree, very, very serious responsibilities. But again, in looking at the role of the governor, that we would all agree is a very, very serious role. And according to the website, he is, in fact, the CEO. And he is charged, the CEO of the central bank, with the day-to-day management, the administration, the direction and control of the business of the bank, and he has the authority to act in all matters that are not specifically reserved for the board. He ensures corporate governance, but he's also there to oversee public relations and external communications, to foster, and I repeat, to oversee public relations and external communications, to foster national and international confidence, to promote financial stability, literacy, and institutional credibility. And I want to repeat the importance of the governor's role in terms of fostering national, and not only national, but international confidence as well. The world looks at us and how we function, especially when we are in these positions of authority. So Senator Shrikissoon spoke about the whole question of independence. And in a sense, we have to say that there is some independence that is required of the governor of the central bank. So that I researched the question of independence, just as a goodly senator. And of course, I too noted that there were several conflicting ideas regarding the level of independence that one may see fit for the governor of a central bank. So that my search revealed several areas of independence, and one being goal independence, where the governor has the right to set its own policy goals, and that's with regard to targeting with the question of inflation and control of the money supply, and of course the whole question of the exchange rate and so on. So that it is in fact so. However, I think all right-thinking people have come to understand, and that is separate and apart from the fact that the relationship is enshrined in law, and that had been clarified by my goodly senatorial colleague Khan, that the relationship is enshrined in law, and it is well established and well known to most and almost to all that many central banks prefer to announce all of their monetary, all of their policy goals in partnership with the appropriate government departments. So that I'm saying, establishing the fact that there is goal independence in terms of the goals of the central bank. However, it is well established and it is enshrined in national law that there ought to be the announcement of the goals of the central bank in partnership with the Minister of Finance. And there are reasons for that, because this in itself increases transparency, and also it adds to the credibility of the goals of the central bank governor and the central bank as well. So that the setting of common goals is what is the preferred situation. Not only is it enshrined in law, it is a preferred situation. And it really does help to avoid situations where you may find that monetary and fiscal policy may be in conflict, and that clearly is not a situation and a combination that you would want to find. That is not at all an optimal situation where there may be conflict in terms of monetary and fiscal policy. There's this whole question of instrument independence as well, where the governor would have his own independence in terms of the way he wants to achieve policy goals and in terms of the type of instruments that he may use or wish to use and the timing of the use and so on. So that is there, that instrument independence, and the goal independence is there in a sense, but we also have to always look at the fact of what is enshrined in our national law and also what is best when what you want, the optimal position that you want is that situation of congruence of monetary and fiscal policy. That combination is what you want, that is in the best interest of the public. So that there's also something, there's also the question of legal independence, and that concerns the whole question of whether or not it is enshrined in law. And in our situation, our national situation is clearly enshrined in law in the Central Bank Act, that the governor and the central bank is accountable to government officials directly, in this case, by legislation. And he's directly accountable through and to the Minister of Finance, and that we have made clear this afternoon. So that even though that there may be, and Senator Shrikissoon alluded to that, there may be some defining degrees of independence. In this case, there's clearly a case of the fact of his role and his accountability being enshrined in law by virtue of the Central Bank Act. And our Senator Khan spoke to particular legislation, the Central Bank Act and so on, but there's also the whole question of the continuing amendments and also the Financial Institution Act of 2008 and also the Exchange Control Act as well, the Heritage and Stabilization Act as well, which all will speak to this whole question of legality and the fact of his responsibility and his accountability being enshrined in law. And again, looking at the question of independence is a question of the management independence, and I will concede to that the central bank and the governor does in fact have authority to set its own operations in terms of appointing staff and setting budgets and so on. So that I will give you that there is some amount of management in the independence, but clearly when one looks at that of the past and the performance of past governors in the central bank, there really has not been positions of conflict before, and and it says to us that the position being put forward by the opposition is really one that has very, very little merit, in that these are not situations which we commonly see at all. As a matter of fact, governments come and governments go, and the turnover rate of central bank governors is quite low. And that speaks to the institution, how it operates as well, and the comfort of operations alongside the government and in particular the Ministry of Finance, the Minister of Finance. And so I I want to posit the view very clearly in just closing this question of independence, that yes, there's some measure of independence in terms of the management functions and in terms of the goal independence to a certain extent and the instrument independence, but very clearly there is in law required relationship that with the Minister of Finance, again, which I repeat, is enshrined in law, and the partnership is absolutely necessary. And on that basis, this motion really would have no merit at all. And so as I said before, the public will agree. And I think many on the independent bench certainly will agree that monetary and fiscal policy really must work in tandem to ensure and protect the interests of the public. That is the ultimate goal. And this is a view that has been agreed on by most, and this is a position which has been, which has taken place over time as well. So that there is an expectation when bodies, any two bodies, are working with the same goal in mind, and each is working from a different perspective, you may have some conflict. But I want to say that those situations should really be few and far between. And that is why it is absolutely necessary that there is consultation. Consultation to inform, this is the Governor of the Central Bank, to inform the Minister of Finance of his position, to articulate very clearly what his position is in the best interest of the public and in the interest of the ultimate goals of the Ministry of Finance, the government, and the central bank. This whole question of good governance and integrity and transparency demands that this kind of consultation is had. And therefore, let me look at this whole, look at the statement which was made by the goodly former governor of the central bank. Clearly, on December 4th, and many in this room have spoken to that, the then governor, and it was at the 5th Monetary Policy Forum, he proclaimed that the country was in a recession after 4 successive quarters of decline in real GDP in 2015. And then he went on to say that 4 consecutive quarters of decline means that the country is now officially in a recession. And as Minister of Trade and Industry, I'd say to you that there are very many businessmen that continue to say to me that it is really when this very unfortunate statement was made by the then governor that you then started to see a slowdown in the economy. In other words, this kind of statement by the governor, without any discussion with the Minister of Finance, clearly sent the wrong signals in this country. Sent the wrong signals, and I can tell you the response by the business community. Hold up, what is being said here by someone of authority? And that clearly set a very negative mood in this country as far as business is concerned. So that disclosure on the economy, Mr. Vice President, it was not discussed. not discussed. And I want to say that even if you didn't look at the law, I would say that it's a question of courtesy, the same kind of courtesy that we extend to each other. A question of courtesy, a question of protocol would have been expected for the very least, even if not enshrined in law. It would have been expected from someone in that position, knowing full well the severity of the statement which he was about to make and the effect it will have not only on the national business community, but on Trinidad and Tobago's position internationally, when looked at internationally. And I said, if not the law, at least courtesy and protocol would have dictated that there would have been some measure of consultation beforehand. As I said before, it is the governor's responsibility to consult and inform the Minister of Finance on matters regarding policy. And Section 49 clearly indicates an obligation. But we could argue about the law, and we could argue here about what is right or wrong. But as I'll tell you what we can't argue about, that basic protocol, basic courtesy, a basic understanding of his role would have required that minister to speak or to consult firstly with the Minister of Finance. He ought to have informed the Minister of Finance about his disclosure of a recession. And it is that it's not, and I think it is the Minister of Finance himself who had said he had asked for a meeting. He had asked for a meeting in advance, but clearly in defiance, or I suppose whatever judgment the then governor would have made, he decided he was not going to discuss. He was not going to send a text message. He was not going to send an email. He wasn't going to call. And he just thought it onto himself. Now is the time to inform the public, and he was going to do just that. And I'm saying to you that that position and those actions are significantly flawed. And I'm and we are all very disappointed on our side in the manner in which the governor behaved. And clearly, he should have enlightened the Minister of Finance before attempting to blindside him. I want to also say, apart from the whole question of what is right and wrong and so on, yes, he has a responsibility to inform. But again, his actions were lawless, and it is my own view and the view of many that the unscrupulous manner in which he dealt with the whole matter is unacceptable. It was unacceptable to the business community. It was unacceptable to the nation at large. Mr. Vice President, his position is a very powerful position. But his behavior and the manner in which he dealt with the seriousness of the disclosure is unacceptable. It was unacceptable then, and it is unacceptable now. And I want to say, in ending this little part of my discussion, that a person responsible for the transactions and this whole question of monetary policy of this country should never act in the manner in which the then governor, acted. And it is at that particular meeting, that fifth monetary Policy Forum. That the governor then went on to disclose the name of several foreign exchange conglomerates and banks in Trinidad and Tobago. And again, that was another point of contention and remains a point of contention within the business community within Trinidad and Tobago. And many lawyers will tell you that the then governor breached several laws. And there's no need for me to detail all of these laws. But there he breached the law in disclosing and in mentioning the top users of foreign exchange. And that brings into question the whole question of confidentiality. Mr. Vice President, when I left university, my first job was as a management trainee at Republic Bank. And on the first day on entering, before I was introduced to anyone else but the HR personnel, I had to sign on to an oath of confidence. And it matters not what, an oath of confidentiality. And that is an oath that I carry with me today. It is well embedded in me as a former banker, and I believe once a banker, always a banker. That's an oath that is well embedded with me, and I well understand it. That there should have been no disclosure by the then central bank governor. And that kind of action, I repeat, certainly did not inspire confidence among the business community. So, as again, the disclosure was in breach of Section 56(1) of the Central Bank Act, Section 8(1) and 7 of the Financial Institutions Act, and it is potentially a breach of also Section 44(1) of the Exchange Control Act. And really, there was no justification for the central bank governor acting in the way in which he did. And again, I'm not going to speak much longer, and I want to emphasize this point about there having been no personality clashes. Again, I say that there were absolutely no personality clashes. That never entered our consideration at all. That was never out there. But I want to highlight the point that this could not have been a question, this occasion could not have been a question of simple oversight. It could not have been a question of simple oversight. Because the Minister of Finance, as I told you before, had requested a draft. He had heard, he knew that this was going to take place. And the Minister of Finance did in fact ask for a draft of the governor's speech before he made his the then governor made his presentation. And it was not given to him at all. And really, I just want to emphasize that even though the Senator Shrikissoon and others spoke to this and they quoted again the governor emphasizing that the appropriate monetary and fiscal policies can only come from the central bank and the Ministry of Finance working together. We have no choice. We can and we should work together to ensure we get the policies right for the country's recovery. We will all be doubly damned despite the vindictiveness and ego keep us from working together to help our country. That is all so. But that statement rings through of what ought to have been the case. And the fact that the central bank governor's actions were a completely different story. A completely different story. And it is that in the course of his doings on that day, December 4th, and I am reminded of the fact, I don't know if his actions were perhaps to distract for what was taking place the day after. For as you know, Mr. Vice President, there was the day after would have been the UNC internal elections, and there was a lot of bacchanal in the public domain about what was taking place there. So I don't know if it was meant to be a distraction, but what I want to clearly place on record, and in response to the motion, which clearly cannot be supported, is the fact that the governor forgot the most important oath, and that is the oath.
Minister, do you have much longer again?
No.
How long exactly?
5 minutes,
5
less.
minutes? Okay.
Yeah. He forgot the most important oath, and that oath is that the country comes first. And whatever his actions were should have been well considered against the backdrop of what's right for the country, particularly at this time, particularly given the economic circumstances at that time as well. It is about country first, and I would want to say that the governor would have well been advised to put aside pride and ego and resentment or whatever there was, to make sure that whatever he did would have been in the best interest of the people of the Republic of Trinidad and Tobago. And I want to say for the final time that it was his duty, it was the governor's duty to work alongside the Minister of Finance for the sole purpose of bettering the country. Now, he may have argued and indeed I think it was Senator Danisha Mahabir spoke to the question of moral suasion as a tool in the governor's arsenal to effect changes on matters of monetary policy. And this whole question of moral suasion is an important tactic used by the central bank to influence and to influence banks into adhering to its policy and guidelines and so on. But I want to highlight the fact that it's in fact a very qualitative approach. A very qualitative approach that is aimed at pressuring different economic agents to comply with the authorities' policy guidelines. And yes, it's a very important process to be considered. But again, what I would have expected from the central bank governor, if he thought that he wanted to encourage or engender some kind of compliance or with policy, or to encourage banks to work in tandem with the central bank or so, I think there are many ways that he could have used to execute moral suasion. He could have had a meeting. He could have called all the bank's executives and stakeholders to meetings. He could have met with the Minister of Finance. There could have been some kind of inspection and visitation or so. He could have asked for records, activities, and so on, to make sure that all kinds of guidelines are being adhered to. There are all sorts of approaches, as I said, qualitative approaches that could have been taken by the Governor of Central Bank if he wanted to exercise moral suasion, as he is able to, as a persuasion tactic, to ensure that all the banks were in fact adhering to policy guidelines and so on. He could have used all of these methods, and he could have written guidelines, letters. He could have written them letters. He could have made public statements. But in the form of probably a general appeal to the public. But he did not. What he did, I would proffer at this stage, was not appropriate. What he chose to do, the line of action which he took, was not appropriate. So the whole question of moral suasion and that argument by Senator Mahabir is an acceptable one. But in this case, the governors of the central bank never chose any one of the appropriate means of moral suasion that he could have if he wanted to engender or to the support of the banking community and so on. So there's no point in belaboring our position on this motion. We will absolutely not support it. We've been very, very clear that the relationship is one that is enshrined in law. I'm not going to discuss anything, have any discussion about political motivation and so on that some of the others may have tried to bring up. All I want to close it by saying is that his actions were unforgivable, unacceptable, unpardonable, and did not inspire any confidence, any public confidence at all. And it is for these reasons that we cannot support this motion which is before us today.
Honourable Senators, it is now time for the tea break. We will return at 5:10, and this House will now stand suspended.